Hello and welcome to Verdictum. I am Ananya Singh and today I will be talking about the journey of rights granted to the LGBTQIA community in India, one case at a time. As we all know, that on September 6, 2018, in the landmark judgment titled Navtej Singh Johar versus Union of India, the five-judge Constitution Bench of the Supreme Court delivered an unanimous verdict and decriminalized homosexuality and certain portions of Section 377 of the Indian Penal Code. The top court's bench, comprising the then Chief Justice of India Deepak Mishra, Justice R.F. Nariman, Justice A.M. Khanvilkar, Justice D.Y. Chandrachud and Justice Indu Malhotra, overturned the previous judgment of Suresh Kumar Kaushal versus Union of India, while holding that criminalization of sexual acts between consenting adults was in violation of Articles 14, 15, 19 and 21 of the Constitution of India. The provisions of Section 377 that deal with the sex with minors, non-consensual sexual intercourse and bestiality, however, continues to be a criminal offence. Though the Navtej Singh case is the most significant case, the journey of granting rights to the LGBTQIA community does not stop here. Several courts across the nation have time and again given many decisions that upheld the rights of the community. Some of such cases are Madhuwala versus State of Uttarakhand. A single-judge bench of the Uttarakhand High Court reiterated that consensual relationship between two adults, even though they are of the same sex, is not barred. The court clarified that it was not illegal to have a romantic relationship between two individuals of the same sex and to live together in pursuance of the same. The High Court dealt with the issue whether the right to life and personal liberty extended to choose a partner and to cohabit with them. The court answered in the positive and said that the liberty granted by virtue of Article 21 of the Constitution was both a human right as well as a fundamental right, and that it was wide enough to include the right to choose a partner regardless of sex and to cohabit with them. Pramod Kumar Sharma versus State of Uttar Pradesh. In the instant case, the appointment of a home guard was cancelled following a video of him engaged in a public display of affection was made viral by someone. When the video was seen by the employer, his appointment was terminated for this sole reason, and the cancellation was then challenged before the High Court of Allahabad. The High Court, while reversing the cancellation and reinstating the home guard back to service, noted that the cancellation order was vindictive in nature, and as has been held in the Navtej judgment, the fundamental right to expression included the right to express oneself sexually with a partner of one's choice. Moreover, the public displays of affection between members of the queer community could not be bogged down by majoritarian perspective as long as they do not amount to indecency or violate the public order. S. Sushma versus Commissioner of Police. This particular case came as a rescue for many queer individuals who were forced to undergo a medical conversion therapy. In the present case, the parents of a lesbian couple opposed their relationship and made them undergo a medical conversion therapy to apparently cure them from being homosexual. The Madras High Court took strong objection to the practice and held that the practice of conversion therapy be prohibited and not to be adopted by any medical professionals in India. The court further held that the queer community must not be subjected to harassment by police or any other authority. It was also directed by the High Court that the union as well as the state government should take measures to spread awareness and sensitize the society to remove prejudices against the LGBTQIA community. Deepika Singh versus Central Administrative Tribunal. In this case, the Supreme Court widened the definition of family under the Indian law, while recognizing that familial relationships may take form of domestic, unmarried partnerships or queer relationships. The manifestations of love and of families may not be atypical, but they are as real as their traditional counterparts. The matter came before the top court with regards to maternity leave application of a woman, which was rejected on the ground that she has previously availed a maternity leave to take care of her husband's children from a previous marriage. Now that she gave birth to her biological children, that benefit was not granted to her. The Supreme Court's bench, comprising Justice D.Y. Chandrachud and Justice A.S. Bopanna, ruled in favor of the woman and held that a woman's statutory right to take maternity leave cannot be restricted because she previously used childcare leave for her non-biological children. The court also said that atypical families are deserving of equal protection under Article 14 of the Constitution and are entitled to avail benefits under the social welfare legislation. And now the most recent case, Supriya Chakrabarti and another versus Union of India. The much-awaited judgment seeking legal recognition of same-sex marriage was delivered on October 17 this year. The Supreme Court considered many questions, such as whether the right to marry was a fundamental right, whether the Special Marriage Act is discriminatory towards homosexuals, what is the scope of the state in regulating the intimate zone, whether the right to enter into a union can be restricted based on sexual orientation, whether transgenders have a right to marry, whether the right to adoption can be conferred to queer persons, among others. A 5-judge constitution bench comprising the Chief Justice of India, D.Y. Chandrachud, and Justice Sanjay Kishan Kaul, Justice S. Ravindra Bhatt, Justice Hema Kohli, and Justice P.S. Narasimha, started hearing approximately 20 petitions on April 18, 2023, and deliberated upon the issue for 10 days. The bench, however, pronounced 4 separate judgments. The majority opinion was articulated by Justice S. Ravindra Bhatt, along with Justice Hema Kohli and Justice P.S. Narasimha, while the CJI D.Y. Chandrachud and Justice S.K. Kaul presented the minority opinion. The CJI said that queer was not an urban elite concept and a natural phenomena existing in India since ancient times. In this regard, he said that adoption rights should be extended to queer couples and that the Central Adoption Resource Authority exceeded its authority in barring unmarried couples, and the CARA regulation was held unconstitutional in this regard. He also urged the state and union territories to take steps to sensitize public about queer rights and not to bar queer people to avail benefits like ration cards, insurance facilities, right to employment, pension, gratuity, among other rights. The Solicitor General Tushar Mehta told the court in this regard that the union government will constitute a committee to determine the rights and entitlements of persons in queer unions. The CJI further said that it is for the Parliament to effect changes in the law, and the Constitution does not grant any citizen a fundamental right to marry, and the same cannot be elevated to the status of a fundamental right. Justice S.K. Kaul concurred with the CJI on grant of certain rights to queer peoples and said that non-heterosexual and hetero unions must be seen as both sides of the same coin, and that legal recognition of non-heterosexual unions is a step towards marriage equality. Justice Kaul further said that entitlements flowing from marriage are regulated by regulations and laws, and tinkering with the Special Marriage Act will have a cascading effect. Justice Kaul also emphasized on the need of an anti-discrimination law, stating that let us preserve this autonomy so long it does not infringe on the right of others. Justice Ravindra Bhatt and Justice Hema Kohli disagreed that there is no fundamental right to marry. It was further held that legal recognition of the right to form a union similar to marriage can only be achieved through enactment of laws by a legislative body, and the court lacks the authority to mandate or guide the creation of a regulatory framework that would confer legal status upon such unions. However, the state cannot be compelled to recognize rights following from such unions, Justice Bhatt said. The 2 judges also disagreed with the CJI on the aspect of adoption. It was said that removing the term marital from Regulation 5(3) could lead to unintended consequences that might involve complex policy considerations that the court cannot fully anticipate. The judges hence decided not to nullify the provision but to place the responsibility upon the state to take measures and address the issues arising from it. Justice P.S. Narasimha also agreed with Justice Bhatt and Justice Kohli and dissented with the CJI and Justice Kaul. Justice Narasimha observed that the benefits of marriage, however fundamental to a fulfilling life, do not make marriage itself rights given or denied to the LGBTQIA community across the nation. With that, I am Ananya Singh. Thank you for watching Verdictum. Do like and share this video and subscribe to our channel for more such informative content. And don't forget to download the Verdictum app on iOS and Android for latest legal news.